Good morning, everyone. My name's John Persinger. I'm with the law firm of MacDonald, Illig, Jones, and Britton. I practice in our Emerging Technologies Practice Group. The Emerging Technologies Practice Group helps clients identify, manage, and mitigate the risks associated with emerging technologies. So we handle things like cybersecurity, e-commerce, social media, crowdfunding. The chair of our practice group, John DeSilva, is here this morning. John's over there waving. He's also the chair of our intellectual property practice group. So if you have questions, you can come to myself. You can go to John as well. The other thing I want to mention is we do a weekly emerging technology tips. So once a week we send out an email that discusses the intersection between the law and emerging technology. It provides some guidance on how to handle certain situations or how to react to certain situations. This week was about spear phishing attacks and legally what you should be doing in response to prepare for or respond to a spear phishing attack. We've written about things such as the National Labor Relations Board and their evaluation of social media policies and employees going on social media in the workplace. If you want to be added to the list, you can email me. My email is on here, or you can email vmadden@mijb.com, and she'll make sure that you get on the list. Today, I wanted to talk about minimizing your cybersecurity liability. And before we get started, I just want to ask, has anyone here ever been suffered a data breach or been the victim of a data breach? No, that's pretty good odds. You have.
Well, not me personally, but I just read that Penn State engineering just got hacked.
That's right.
Actually, it was in November. We just found out about it.
That's right. Yeah, it takes a while for these breaches to become public.
Yeah.
And I'm going to get into a requirement by law which entities have to notify you when it occurs in a second. But I gave a talk on Tuesday, and there were 2 individuals whose companies had suffered data breaches. So I thought that I'm surprised that there aren't more here this morning who have suffered one, because it is a growing trend. As you all have seen in the headlines with Target and Sony and Home Depot, attacks are on the rise. There are those are the big nationwide attacks, but there's also been nationwide attacks with a local impact. The Anthem breach, the White Lodging breach. There's also been local specific attacks, which I don't want to get into because I don't want to embarrass any company or entity, but you can read about it in the news. So in terms of thinking about minimizing your cybersecurity liability, I want you to be thinking about 2 things: reasonableness and data breach notification laws. On the first part, with regards to reasonableness, I'm going to start by asking another question. Has anyone here ever been involved in a car accident? Okay, obviously. Has anyone been involved with a lawsuit stemming from a car accident? Not one person. Over here, 2 people. Okay. So as I mentioned, there's no federal law, there's no state law that says do not get in a car accident. And if you do, you're going to be liable. It's the same way with data breaches. There's no state law that says, or federal law that says, do not cause a data breach or you will be liable. But there's still lawsuits that stem from car accidents. And do you know why? Do you know what they allege? Anyone who hasn't been involved?
Somebody was negligent.
Exactly. That's exactly what they allege. This isn't a state law or a federal law. This is what we call common law. This is law that has been developed by British judges over the years, which we adopted into our legal system. It's negligence. And to make a claim of whether someone was negligent or not, do you know what they need to prove? Putting you on the spot, Brian. Negligence. But how do they go about proving negligence? They go about proving negligence by proving whether you had acted reasonably under the circumstances. So, were you texting? If you caused the accident, were you texting? Were you drunk? Were you speeding? Was there snow? Was there a tornado? Those are all factors that determine whether you had acted reasonably under the circumstances. This is the same claim that the majority of the legal suits that have occurred after data breaches are alleging, that these companies who suffered the breach are negligent, that they didn't act reasonable under the circumstances in protecting people's information, personal identifiable information, protected health information, credit card numbers, bank account numbers. So it comes down to what's reasonable. This is where I make my money. Lawyers argue about what's reasonable all the time, every day in court, as with car crashes and car accidents. What is the reasonable standard for preparing for, preventing, and responding to a data breach? Do you have updated antivirus software? Do you counsel your employees on passwords? Are passwords 1, 2, 3, 4? Do you have employees who have left laptops or mobile devices in public areas? What's reasonable? So when you're thinking about minimizing your cybersecurity liability, you want to think about what is the most reasonable things that you should be doing. And so again, because this presentation is long, we won't get into all of it, but this presentation, which you will get, talks about things that you should be doing to prevent a breach, what you need to be doing after a breach, and it's all with a goal toward minimizing your cybersecurity liability. Does that make sense, that reasonable standard? It's so tough to pin down. It's much easier when there's a statute that says, don't do this, and if you do, you're going to be liable, because then you know where the line is. But with a reasonable standard, it's really a matter of what a judge will find, what a jury might find, what the lawyers for each respective party will argue. Right now, we haven't seen too many cases that have actually gone to trial. A lot of the companies, excuse me, have just decided to settle. That's what Target did. Target is agreeing to pay $10 million as a result of its data breach. So that's the first thing is I want you to keep in mind is reasonableness. The second thing I want you to keep in mind are state data breach notification laws. There are 47 states that have enacted data breach notification laws. In the event that you suffer a data breach and you believe that clients, customers' information has been compromised, under these state laws, you are required to notify your clients and customers. The interesting thing about these laws, because they are in 47 different states, they are geared toward protecting the individuals in those states. So you have to comply with each state law where you have a client or customer. So if you have clients and customers in all 47 states, you have to comply with all 47 different state notification laws. For the most part, they are the same. I'll skip ahead. So for the most part, there are some similar requirements throughout these laws. Primarily, one being that you need to notify them. Two, that you need to do it within a certain time period. The time periods are usually about 30 days, as I've seen in the notification laws. And three, if you have a number of clients that surpass a certain threshold, I think in some states it's about 5,000, then you need to notify the state attorney general or the state agency that is responsible for enforcing these types of actions. So that's another thing that I want you to keep in mind, that if you do suffer a breach, then you have to respond, and you need to respond immediately, not only because of these state data breach notification laws, but also because it becomes a matter of reasonableness. You know, if you have a breach and you know if a breach occurs, but you do nothing, you don't notify customers, you don't fix your firewalls, then that could exacerbate your liability. So those are the two main things that I want you to be thinking about: reasonableness, state data breach notification laws. A quick note on the data breach notification laws. There are a number of bills being kicked around in Congress to enact a federal data breach notification law so that there will just be one standard. I don't know when those bills will be passed. There is a lot of momentum to create a federal standard, so unlike a lot of bills, I don't envision this one to die, but it's a matter of what's actually going to be in the bill at the end of the day. So I'll continue to keep people posted, keep Kathy informed. Our weekly tips will keep you informed. But until that happens, you're still responsible for complying with all 47 different state notification laws. The other thing I want to touch upon, since I do have a few minutes, thanks to Don, just briefly, I always get this question about how much is a breach going to cost me? And it's really tough to pin down the numbers. There's studies that have put out various numbers. One of the more reliable studies that I think I've seen has been 5.85 million for a breach with less than 100,000 clients, sometimes $188 per person. So in your businesses, when you're thinking about adding up the costs of, we're talking earlier about, well, how much is it going to cost me to get a cybersecurity consultant in and make sure that I'm safe and protected and to update my network? How much is it going to cost me to get insurance? Are those costs going to add up to what it will actually cost you in the event that you do have a breach? And then one final thing that I do want to mention, if you're wondering where these costs are coming from, there's the initial investigation, hiring a cybersecurity consultant to figure out what was breached, where the breach occurred, how to stop the bleeding. You've got to send out letters to all the individuals who may have been compromised. You're going to have to hire attorneys to deal with any claims from customers or any investigations by federal and state agencies. And there may be fines eventually by a state or federal regulatory body. There's also indirect costs. I think Target, their business was down $1 billion over the span of a year. And so that is, I think you can tie that directly to the breach and customers just shifting away to other outlets. So I just want to leave you with, be proactive. The best way to show that you're being reasonable is that you've been proactive in testing your networks, educating your employees, and that you've got a plan in place in the event that a breach does occur. 2, respond immediately because you have to under the state data breach notification laws, and again, because it shows that you're acting reasonably. And 3, just prepare for the damage. There are going to be costs. Even if you don't get sued, there's still going to be the cost of notifying customers and clients about the potential breach and hiring someone to come in and make sure that you've stopped the bleeding. So those are just 3 things that I want to leave you with, and I'll turn it back over to Kathy.